Roberts is nothing but one of these Indiana descendants of Klan types. He's a brutal, evil racist. No doubt about that, and he will go down in history as such. So this is the reason he was attempting to rewrite history. But the problem for Justice Roberts, as it was for Tierney, you can put your thumb in the dike, but the dike eventually will overflow and it will wash you away. And that's what will happen to these people. It set the Republican Party back. And at the same time, the two cases decided today will be detrimental to the Republican Party because they're exposed as racists everywhere. Now back to Ms. Davis down in Texas. The legislature did not pass this. Texas Perry, he's the governor, a very reactionary person, ran for president. He'll not be able to do that again. But he will get a special session of the Texas legislature just to deal with the 20-week abortion thing. And this is not really about the abortions, 20 weeks or what have you. This is about cementing this reactionary coalition that they had. And they can win. It's been demonstrated in states. Back to Tip O'Neill's maxim on all politics are local. So thus they are using that. But this is also a time of great debate. We look at it from everything from national security, these various internet operators out there, and this changes the dynamic of many things, because many of these reactionaries that oppose the abortion mandates has been around since Roe v. Wade. The same people that want to redraw voting lines come with voting ID. This is Jim Crow. But the only problem there is apathy, and when the people demand things, the people that have the potential to demand the redoing of the Voter Rights Act through Congress are multiple, in other words, millions stronger than these so-called Tea Parties that went out there. Once they get organized, once they get vocal, and now you have a linchpin called social media. Mr. Snowden has used it brilliantly. He's launched a worldwide campaign, so has Julian Assange. So now what you have is not only questions in terms of privacy out there, but you have within the U.S. Now what has happened in Mr. Snowden's case is he's exposed the U.S. To contradictions. China has blasted them, so has the Russian Republic. So this is on the international situation. You've not heard about Syria, and poor old President Obama, he's traveling on the continent in Sierra Leone. You hear very little about him. He's been literally knocked off the front and the back page of the newspaper. So these are the events that shape us on the 27th day of June 2013. One step forward, two steps backward. This is Boston Red, and as a poet laureate of Newark, New Jersey, one L.A. Bill Graham would say, peace out, good day, and we'll talk to you on Friday Java and the week that was. Now we are sort of back to our regular production facilities, and also on the Monday morning quarterback. Incidentally, Mr. Hernandez, I believe, for the Patriots, has been arrested for murder of one of his associates. Good day.
As one of the worst days for civil rights and civil discourse in this country's history. I am Marcia Fudge, and I'm the chair of the Congressional Black Caucus. I was hopeful that today would bring better news, but the decision that came down today is certainly one that has disappointed us all. I would like to begin by having our Assistant Democratic Leader, Jim Clyburn, come and give us a few words. Mr. Clyburn.
Thank you very much, Madam Chair, colleagues. About 4 years ago, I think the Supreme Court sort of gave us an indication that today's result could be what it is. I don't remember the case. The name of the case was a North Carolina case. The court seemed to signal at that time that the kind of history that we used in 2008 when we reauthorized the Voting Rights Act they considered to be outdated, and that something needed to be done to update the formula that we use. Now, we in this Congress did a study. If my memory serves, it was 15,000-page study. And the vote in the Senate was 98-0. The vote in the House, I believe, was 390-33. And we decided that enough evidence was there in front of us to require a reauthorization of the Voting Rights Act. That was just 2008. Now, if we were to look, in my opinion, if we were to look at the reason that the Supreme Court gave in talking about our failure to take into account the progress that has been made, I believe the best way to take into account the progress that's being made in this country on any subject is to look at the actions as well as the debate that is undertaken by those who are elected every 2 years, and in some instances 6, but the House is reelected every 2 years. We stay very close to the people, and we then issued our opinion. But we saw, when this case was being discussed, Justice Scalia seemingly wanting to inject himself and the court into this, saying to the effect that the Congress seemed not to be able to get it right. I think this is a very sad day, but let me conclude by saying this. If we were to accept the Supreme Court's reasoning that we didn't take into account the progress that's been made, I want all of us to remember that in 1865, when we had just after the Emancipation Proclamation been in effect for 2 years, people of color were elected to legislatures all over the South. In South Carolina, 2/3 of the South Carolina General Assembly was African American. So in 1870 and 1880, the same decisions, assessment could have been made. Look at the progress that we have made. But then, in 1890s, you started getting legislative actions, and we started getting a United States Supreme Court decision, Pleasant versus Ferguson, which started us down the road, and then by 1900, there were no African Americans left. And so what I'm saying here today is I can envision that at the beginning of the next legislative session, a lot of states, including my home state, will be taking a look and probably will be having some redistricting, not just of congressional seats, but also of legislative seats, because we found out in the Texas case that it's not beyond some of our friends to have special legislative sessions and special redistricting in the interim of the 10-year period. That was done in Texas several years ago, and I can envision this Supreme Court decision leading to that for next year as well. This is a sad day for civil rights, and I would hope that the Congress would step in and in the bipartisan manner in which, and I might add, the House, there were more Republicans than Democrats that voted for the reauthorization in 2008. I would hope that kind of bipartisanship could take place at this time. And with that, I'm pleased to yield to the chair of the Congressional Asian Pacific Americans Caucus, Ms. Judy Chu.
As chair of the Congressional Asian Pacific American Caucus, I join my colleagues of the Tri-Caucus in condemning today's Supreme Court decision as a setback for all Americans. It is with a heavy heart that we see this erosion of the Voting Rights Act that ensured the promise of democracy for each and every citizen. The 14th Amendment provided equal protection for all of us under the law. The 15th Amendment made the right to vote colorblind. Both were undercut by poll taxes, literacy tests, and voter intimidation. But it was the Voting Rights Act that put an end to all of that. It ensured an impartial review of new voting laws for regions that have a history of discrimination at that ballot box. When that section was renewed in 2006, it passed by a bipartisan vote of 390 to 33 in the House and a unanimous vote in the Senate, and was signed into law by George W. Bush. Despite this overwhelming bipartisan support, today the Supreme Court struck down one of the key components of the Voting Rights Act on the ground that it's outdated. While the Asian American community knows all too well how easily the right to vote can be taken from a group that is not protected. When Congress passed the Chinese Exclusion Act of 1882, it denied any Chinese immigrant the right to become a naturalized citizen and therefore from being a voter in the United States. And it stood in effect for 60 long years. We are now only at the present time overcoming the scars of disenfranchisement, and that's why we know all too well how precious the right to vote is. Passing the Voting Rights Act was the right thing to do in 1965. Renewing it was the right thing to do in 2006. And updating the formula to ensure those protections remain intact for the American people is the right thing to do now. I urge every member of Congress, regardless of party, to join us in ensuring that the Voting Rights Act remains the pillar of our democracy that it has been since its inception.
It is just truly mind-boggling to me today that we have the highest court in the land that can't really make the kind of decision that this country deserves. They want to have their cake and eat it too. They recognize that discrimination and racism still exist in this country, yet they would strike down the very parts of the very law that have changed what they say has made this country better. It is disconcerting at best to know that just in 2012 there were 22 laws and 2 executive actions restricting voting rights in 17 states across this country. Even worse, there were 176 restrictive bills that were filed in 41 states. And they say that things need to be changed. Yes, they need to be changed. Not only should they not have struck down Section 4, they should have expanded it. I would ask now that my colleague from Texas, Mr. Pete Gallego, please join us. Thank you, Pete.
Hello, I'm Pete Gallego. I'm the congressman from the 23rd District in Southwest Texas, member of the Congressional Black Caucus and vice chair of the caucus's task force on civil rights. Today's decision, it's a bad day, a sad day for the democratic process. The disenfranchisement of voters based on race and ethnicity still happens. In the 23rd District of Texas, which I represent, a federal court found that the map drawers had deliberately minimized the voting strength of the Latino community. Emails from map makers revealed that the redistricting strategy was to make the 23rd a Latino opportunity district in name only. Latinos with high voter turnout were taken out of the district, and they were replaced with Latinos with a very low history of voter turnout. In essence, gaming the system. That's what the safeguard was to Latino voters. Today, we see that communities of color, communities of interest, have always had a referee. They've had someone who will call a foul ball a foul ball. And today, that opportunity to go to that referee or to go to that umpire has been stricken by the court. 15 million Latinos across the country are safeguarded by the preclearance provisions of the Voting Rights Act. The preclearance provision protects Latino voters in Arizona, in Georgia, in Texas, portions of California, Florida, New York, and more. 32%, nearly a third of Latinos in the United States live in jurisdictions that are covered by preclearance. In 20